Very good morning, all the participants. Before this video, we had prepared a video containing the overview of Insolvency Act in Malaysia. Now, this is an attempt to understand it section by section, the Insolvency Act in Malaysia. So I hope my screen is visible to you. Now, what is this Insolvency Act of 1967? The Insolvency Act 1967 is Malaysia's main law on how individuals and firms deal with being unable to pay their debts. It governs everything from voluntary repayment plans to formal bankruptcy proceedings and tells us who has the power over a bankrupt person's assets, what rights creditors have in this regard, and how a person can eventually be discharged from bankruptcy. It applies to individuals and business partnerships and not to companies because such provisions regarding companies they fall under the Companies Act, on which we have prepared a separate video. It covers all of Malaysia, Peninsular, Sabah and Sarawak. And latest amendment act it was in force on 6th of October 2023. So it covers amendments up to 2023. Part 1 is preliminary, which deals with the definition and scope. Sections 1 and 2. So, section 1, what it says, short title and application, as in almost every law. So, this law is officially called the Insolvency Act 1967 and it applies throughout Malaysia. Now, what does apply throughout Malaysia means? So, whether you will live in Kuala Lumpur, Kota Kinabalu or Kuching, this act covers you as if you are an individual or firm that cannot pay debts. But this act does not apply to companies. Companies face winding up rules under the Companies Act 2016. Section 2, which contains some key definitions. Bankrupt is a person who has been formally declared unable to pay the debts by order of a court. Creditor means someone who is owed money. It could be a bank, a landlord, a supplier of goods or services. Debtor means the person who owes money. Property means everything of value. It could be land, money, goods, business rights, anywhere in the world. And provable debt is a debt that can be claimed in bankruptcy proceedings. Secured creditor. Secured creditor is a creditor who holds a mortgage or charge on your property as security. Besides that, there are some general definitions also, like the definition of advocate, affidavit, etc., which can be ordinarily understood. DGI, Director General of Insolvency, the government official who takes over and manages a bankrupt's assets. Social guarantor, someone who guaranteed a loan for education, vehicle, personal use or housing. So they have special protections because sometimes by virtue of social relationship, you may guarantee a debt of somebody else. So there are special protections available to such social guarantors. Ordinary resolution means a decision passed by majority in value among creditors who vote, and majority here means simple majority. And special resolution, it needs majority in number and at least 75% in value of voting creditors. Court here means the High Court. It has exclusive jurisdiction in bankruptcy cases, and nominee means a licensed professional who helps manage a voluntary arrangement between a debtor and creditors. Now let us see this voluntary arrangement and bankruptcy proceedings, section 2A to section 35A. Now what is voluntary arrangement? A voluntary arrangement is a formal repayment plan agreed between a debtor and their creditors before the debtor is declared bankrupt. It is Malaysia's way of giving people a second chance to sort out their debts without going through full bankruptcy. Here, the debtor proposes how they will repay their debts. For example, pay 60 cents on every ringgit owed over 3 years. A licensed nominee supervises the process and ensures the data follows through. And once approved by the creditors by way of special resolution, all creditors, even those who voted against, are bound by such voluntary arrangement which involves a formal repayment plan. Section 2B and C. Who can use a voluntary arrangement? Any individual debtor who has not yet been declared bankrupt can go in for this voluntary arrangement. A business firm, if a majority of partners consent to such voluntary arrangement, it must be filed before being adjudged bankrupt, and a person must appoint a registered nominee to assist, and it cannot be used by an undischarged bankrupt, and it cannot be used by an LLP. So think of this like a structured repayment deal. You negotiate with your creditors, and if they agree, you avoid bankruptcy. You need a professional helper, the nominee, like a licensed accountant or lawyer. And if you are already bankrupt, then this option is no more available to you. And for partnerships, you need your co-partners on board. So majority have to give consent. Section 2D and 2E, interim order, a protective shield. So what is an interim order? When you apply for a voluntary arrangement, the court issues an interim order, a temporary legal shield protecting you while your plan is being prepared. What the interim order does? It stops any new or ongoing bankruptcy petitions against you. It pauses all other legal proceedings, executions, or debt recovery actions. Key rule is it is valid for 90 days only and no extension is allowed, and you must notify your nominee within 7 days, and nominee notifies all creditors within 7 more days, and only one application is allowed per debtor within any 12-month period. Section 2F, 2G, 2H, the nominee, your voluntary arrangement manager. Who is a nominee? A nominee is a registered professional who prepares your proposal, summons creditors, and supervises the arrangement. Who can be a nominee? A registered chartered accountant or an advocate and solicitor. Must be registered with the DGI, must not be an undischarged bankrupt, have a criminal record for fraud, or have a mental disorder. Penalties for acting without registration. If you are not a registered professional, then, and if you act without any such registration, then there is imprisonment up to 2 years or fine of 15,000 ringgits or both. And in case of continuing after the registration expires, it could land you in jail up to a period of 1 year or 5,000 ringgits of fine. The record is DGI maintains a public register of all registered nominees. Section 2I, meeting of creditors, approving the plan. What happens at this meeting? The nominee summons all creditors to consider and vote on the debtor's proposed repayment plan. The debtor must provide a statement of affairs, which shall include complete list of assets, creditors, debts, and other liabilities. Approval rule is you need a special resolution, majority in number, plus 75% in value of creditors. No modification that changes it from a voluntary arrangement by the debtor is allowed. Debtor must consent to any modification, and it cannot touch a secured creditor's security without their agreement. It cannot rearrange priority of preferential creditors without their consent. So these are the rules for approval of any such repayment plan. Fraud warning, false representations to get creditors' approvals could lead up to 2 years in jail or 5,000 ringgits of fine. Section 2J, 2K, 2L, which includes approval, effect, and review of the voluntary arrangement. What is the legal effect? After the meeting, the nominee reports the decision to the court, and if approved, the voluntary arrangement is binding on all creditors who had notice, even those who voted against it. The interim order expires 30 days after the court seals the report, and any pending bankruptcy petition is treated as dismissed unless court orders otherwise. Debtor cannot take new credit facilities during the voluntary arrangement period without all creditors' agreement. Now, what it means for you? Once creditors vote yes, even the no voters are bound, like a majority vote rule. The voluntary arrangement is now a legal contract between you and your creditors. During the voluntary arrangement, you must keep to the plan. No new debts allowed without approval of all the creditors. Review right. Any creditor, the debtor or nominee can apply to court within 30 days if the voluntary arrangement was unfairly prejudicial or irregularly handled. Section 2M to 2Q, managing and concluding the voluntary arrangement. Section 2M says the debtor can replace the nominee at any time before the voluntary arrangement ends. The interim order continues. No time extension is granted. Section 2N, the nominee supervises the implementation process. If debtor or creditor is unhappy with nominee decisions, they can apply to court for review. Section 2O, if the debtor fails to comply, any bound creditor may file or proceed with a bankruptcy petition. Section 2P, the voluntary arrangement ends automatically if the debtor dies. And Section 2Q, the minister sets the scale of fees nominees can charge. So what is key takeaway? A voluntary arrangement is like a supervised probation. Follow the plan and avoid bankruptcy. Break the plan and creditors can go straight to court. Section 3. Acts of bankruptcy. What is an act of bankruptcy? Certain specific actions that legally prove a debtor cannot pay their debts. A creditor needs to point to an act of bankruptcy to file for your bankruptcy. What are the examples of acts of bankruptcy? They are given in section 3. Making a fraudulent transfer of property to defeat creditors, fleeing Malaysia or staying abroad to avoid paying debts, closing your home or business to hide from creditors, filing a declaration that you cannot pay your debts, giving notice to creditors that you have suspended payment, and execution, court enforcement is levied against you for 1,000 ringgits or more. A court bailiff reports you had no seizable property. So all these are examples of acts of bankruptcy. The most common act of bankruptcy, Section 3I. A creditor with a final court judgment serves you a bankruptcy notice requiring you to pay, and you must either pay or secure or compound the debt or show a valid counterclaim within 7 days if served in Malaysia, and failure to respond means that you have committed an act of bankruptcy. Bankruptcy rules. So what are the rules for serving bankruptcy notice? It must be in prescribed form. It should be served personally or by substituted service. If you are hiding slightly overstated amount, does not invalidate it unless you specifically dispute it. Who counts as a debtor for this act? Anyone personally present in Malaysia, ordinarily resident here, carrying on business here, or a partner of a Malaysian firm is considered as a debtor for this act. Section 4 and 5. Who can a creditor? When can a creditor file for your bankruptcy? Section 4. The court may issue a bankruptcy order when a valid bankruptcy petition is filed by a creditor or by the debtor themselves. Section 5. Conditions a creditor must meet to petition. The debt owed must be at least 1 lakh ringgits as amended by Act in 2020. The debt must be a liquidated sum payable now or on a future certain date. The act of bankruptcy must have occurred within the last 6 months. The debtor must be domiciled or personally present in Malaysia or be a partner in a Malaysian firm. What is important is a creditor cannot use a bankruptcy petition as a debt collection tool for small amounts. The 1 lakh ringgits threshold is a significant protection for debtors. Section 6. The creditor's petition. How does the court handle a creditor's petition? Court examines the petition at a hearing. The debtor may appear and contest it. Court can dismiss the petition if the debtor proves no valid act of bankruptcy or shows a genuine counterclaim. Court can substitute the petitioner with another creditor if the original creditor does not proceed diligently. What are the outcomes? Dismiss the petition, debtor is safe, make a bankruptcy order, debtor is declared bankrupt, and stay the proceedings temporarily. What are the tips for debtors? If you receive a bankruptcy notice, seek legal advice immediately. You have only 7 days to respond or you commit an act of bankruptcy. Section 7. The debtor's own petition. Voluntary bankruptcy. Can you declare yourself bankrupt? Yes. Under Section 7, a debtor can file their own bankruptcy petition. This is called a debtor's petition. Why would someone do this? To get protection from overwhelming debt and creditors' pressure, to trigger an orderly process of resolving debts, and sometimes preferable to facing multiple lawsuits. What are the requirements? The debtor must file a declaration of inability to pay the debts, and court will make a bankruptcy order based on this petition. But the caution is that once declared bankrupt, severe restrictions apply to your daily life. Always explore a voluntary arrangement first. Section 8. What happens the moment a bankruptcy order is made? What are the immediate effects of a bankruptcy order? All the bankruptcy property immediately vests or transfers to the Director General of Insolvency. You no longer own your assets. No creditor can sue you, execute a judgment, or take any action against you without the leave of the court. And all existing legal proceedings against you are stayed or paused. What are the exceptions for secured creditor? A secured creditor, for example, a bank with a mortgage, can still enforce their security. For example, they can foreclose on your house. They may also claim interest on their secured debt up to the date of full payment. The key idea is that a bankruptcy order creates a freeze on all actions against you, but your property now belongs to the Director General of Insolvency to distribute to the creditors. Section 10 to 11. Interim receiver and special manager. Section 10. Interim receiver. Court can appoint the DGI as an interim receiver even before the bankruptcy order is made to protect assets from being dissipated. When such an order will be issued, if the court thinks that the debtor might hide or transfer property before the final order. Section 11. Service of stay. Once the court issues the stay of proceedings, a copy must be served on all creditors involved in the stayed proceedings. Section 12. Special manager. Court may appoint a special manager to manage a bankrupt's business. It is useful where the business needs to keep running while the estate is being wound up. And who pays? The special manager's fees comes from the bankrupt estate. It is paid by creditors essentially, right? So think of it this way. The court has many tools to prevent asset stripping before the formal order is made. Section 15 and 16. Section 15. Meeting of creditors. After a bankruptcy order, the DGI calls a meeting of creditors. This is the key meeting where creditors take stock of what the bankrupt owes. DGI gives at least 7 days notice. The DGI chairs the meeting and at least 3 creditors must be present for a quorum. Section 16. Regarding statement of affairs, the bankrupt must submit a detailed statement of affairs within the time directed by the DGI, and it must include all assets, liabilities, creditors, and causes of financial failure. What are the consequences of not filing the statement of affairs? The court can compel the bankrupt to attend and answer questions, and deliberate non-compliance is treated as contempt of the court. Section 17. Public examination of the bankrupt. What is public examination? The court holds a formal session where the bankrupt is publicly questioned under oath about their finances, assets, and conduct. Who can ask questions? The DGI, any creditor who has filed a proof of debt, or their lawyers. What is examined? How did you accumulate debt? Were there any fraudulent transactions? What happened to your property? Did you make any suspicious transfers? Why are you insolvent? And consequences of lying or refusing to answer because the bankrupt is under oath. So lying is a perjury, and refusing to answer without good reason can result in committal to prison. Note, small bankruptcies may be exempted from public examination. Section 18. Composition or scheme of arrangement. What is this? Even after a bankruptcy order, creditors can still agree to a composition, paying a percentage of debts, or a scheme of arrangement, a repayment plan. How does it work? Creditors vote by special resolution to accept the proposal. The court must also approve it, and if approved, the bankrupt can avoid full bankruptcy administration. How it is different from voluntary arrangement? So voluntary arrangement is used before bankruptcy, and this composition or scheme covered under Section 18, it is used after a bankruptcy order. So what is the practical use? Sometimes it is better for creditors to accept 70 cents on every ringgit through a quicker composition than to wait years through full bankruptcy proceedings. Section 25. The Consultative Committee. Creditors can form a consultative committee to advise the DGI on how to manage the bankrupt estate. What is the role of this consultative committee? It acts as a watchdog over the DGI's decisions. It can give advice on selling assets, running a business, etc. DGI must follow directions from general creditor meetings which override committee advice in conflicts. Why it matters? If you are a major creditor, you may have a seat on this committee, giving you some control over how the estate is managed. It is not mandatory. Not all bankruptcies will have a consultative committee, usually only larger or more complex estates. Section 27 to 30. The bankrupt's duties to disclose and cooperate. Section 27 says that you must disclose and assist in realizing all your property. This is your fundamental obligation. Section 28 says that the court can arrest and detain a debtor who is likely to abscond or remove property to avoid bankruptcy proceedings. Section 29 says that a detained debtor can be released on providing adequate security, which could be in the form of a bond with the sureties. Section 30 says that all letters addressed to the bankrupt may be redirected by the DGI. The DGI can intercept your mail to find hidden assets. Why these rules exist? Without them, bankrupts could hide assets from creditors. The law treats concealment very seriously. It's a criminal offense. Section 31 and 32. Discovery of property and settling creditors list. Section 31. Discovery of bankrupt's property. The DGI can summon any person, not just the bankrupt, to be examined about the bankrupt's property. Banks, business associates, family members, anyone who is believed to have information can be called by the DGI. The court can order disclosure of documents and accounts. Section 32 deals with list of debtors to the estate. The DGI must prepare a list of all people who owe money to the bankrupt. These are assets. People who owe the bankrupt money are part of the estate. So DGI then collects these debts for distribution to creditors. Even if someone owes you money, that money now belongs to your creditors once you are bankrupt. Section 33. Court discharge. A bankrupt can apply to the High Court for discharge at any time if court considers the conduct, the cooperation, payment to creditors. So court may grant absolute discharge or conditional discharge or suspend or refuse to grant discharge to the bankrupt. Section 33A. DGI certificate discharge. The DGI can issue a certificate of discharge without court involvement, which is a faster route, and the requirements for issuing a DGI certificate of discharge, that is, bankrupt has cooperated fully and paid the sum which are determined by DGI. Section 33B says that creditors can object to the DGI certificate. Creditors who filed proof of debt can object, but they must do so within 21 days of receiving DGI's notice. And grounds are the bankrupt committed an offense, discharge would harm estate administration, or bankrupt failed to cooperate. So these could be the grounds whereby creditors can object to the DGI certificate. Section 33C. Automatic discharge after 3 years. After 3 years from submitting the statement of affairs, a bankrupt is automatically discharged if they paid the DGI's determined sum and cooperated fully. How DGI calculates the payment amount? It considers the current income, spouse income, family expenses, earning potential, economic conditions, assets available. Suspension of automatic discharge. If the bankrupt failed in their duties, so discharge is suspended for up to 2 more years. And DGI serves notice of suspension at least 6 months before the 3-year period ends. Why this matters? Before this reform, People could be stuck in bankruptcy for decades. Now there is a clear 3 to 5 year exit pathway, and after discharge, you get a clean slate with limited exceptions. Section 35. What discharge does and does not release you from. Discharge releases you from almost all provable debts owed at the time of bankruptcy, but discharge does not release you from debts owed to the government of Malaysia or any state, tax and revenue offense debts, debts obtained through fraud or fraudulent breach of trust, or fines imposed for criminal offenses. Can government debts be paid? Yes, but only by written certificate from the finance minister, Mentri, Besar, or Attorney General. What is the effect on others? Discharge does not release any guarantor or co-debtor from their liability, and your surety or guarantor still owes the debt even after you are discharged. Now let us see the disqualifications and disabilities of a bankrupt, which are contained in sections 36 to 39. Section 36 says that once you are declared a bankrupt, you are automatically disqualified from being appointed or acting as a sessions court judge or magistrate. You are automatically disqualified from being nominated, elected to, or holding office as a councillor of a local authority. When disqualification ends, when the bankruptcy order is annulled, or when discharged with a certificate that bankruptcy was caused by misfortune and not misconduct. Section 37. Regarding vacating current office, if you are already serving as a magistrate, sessions court judge, or local authority councillor, when the bankruptcy order is made, your office immediately becomes vacant. So bankruptcy disqualifies you from certain public offices. It is meant to ensure public trust in office holders. Section 38. Day-to-day life as an undischarged bankrupt. What you cannot do without DGI or court permission. You cannot maintain a lawsuit except for personal injury or claims. You cannot travel outside Malaysia. You cannot start or run a business alone or in partnership. You cannot become a company director or be involved in company management. You cannot work for or be managed by your spouse, children, or parents or siblings in their business. Right? But what you must do every 6 months, you have to report all money and property received to DGI and hand over what is not needed for basic family expenses. You should immediately report any windfall above 500 ringgits that is not regular income. You should immediately inform DGI of any change in your home address. So breach of any of these conditions amounts to contempt of court. Section 38A and 39. Travel restrictions and public register. Preventing travel abroad. The DGI can issue a notice to immigration officers to prevent an undischarged bankrupt from leaving Malaysia. Immigration officers can seize and hold your passport or travel document. How to get permission to travel? You have to apply to the DGI or court for written permission, and it is usually granted for genuine emergencies or work. Section 39. List of undischarged bankrupts. The DGI maintains a public register of all undischarged bankrupts. Anyone from the public can inspect this list at any DGI office. Copies are available on payment of a prescribed fees. A deceased bankrupt's name is removed 5 years after the estate administration ends. What is the practical impact? Employers, banks, and landlords routinely check this register before hiring, lending, or renting. Now let us go to part 3, which deals with administration of property, which is contained in sections 40 to 69. Section 40 and 41. Which debts can be claimed in bankruptcy? Section 40 talks of provable debts. So all debts and liabilities that existed when the bankruptcy order was made can be proved or claimed. Future and contingent debts are also provable. The DGI estimates their value. But pure unliquidated damages, For example, unquantified tort claims cannot be proved. A creditor who had notice of an act of bankruptcy cannot prove for debts contracted after that notice. Section 41. Mutual set-off. If you and a creditor owe each other money, the amounts are netted off and only the balance can be claimed. Example, you owe bank X 1 lakh ringgits, but bank X owes you 20,000 ringgits on a deposit, so bank X can only prove 80,000 ringgits. Why set off matters? Because it is fair, neither party is treated as owing the gross amount when mutual dealings exist. Section 43. Order of payment from the bankruptcy estate. Who gets paid first or the priority of debts? First of all, secured creditors from their security. For example, house is sold, bank is paid off. Cost and expenses of the bankruptcy proceedings. Priority debts are paid equally, pro rata if insufficient. Local rates and land tax within 12 months before bankruptcy. Income tax up to 1 year's assessment. Employee wages and salaries up to 1,000 ringgits per employee for the last 5 months. Provident fund contributions last 12 months. Workmen's compensation. Then all remaining unsecured creditors are paid equally, pari passu, and any surplus is returned to the bankrupt. So this is the order of payment which is done from the bankrupt estate. Section 47 and 48. What property does the DGI take? So DGI's title relates back to the date of the first act of bankruptcy up to 6 months before petition, and all transactions from that date may be undone. Section 48. All property belonging to or acquired by the bankrupt in Malaysia or abroad, property held in trust for others is excluded, and business goodwill and book debts are included. Powers and rights the bankrupt could exercise for their own benefit are also included. So what you keep or what the DGI cannot take, if there are any tools of your trade, if there is a necessary wearing apparel and bedding for you, your wife and children, basic household necessities as may be prescribed, property owned on trust for someone else. So these exemptions ensure you retain basic dignity even during bankruptcy. Section 52. Voiding pre-bankruptcy gifts and settlements. So what is this about? If you gave away property before going bankrupt to avoid creditors, so that gift can be held to be void and that gift can be reversed. So there is a 2-year rule. Gifts of property made within 2 years before bankruptcy automatically void against the DGI. And 5-year rule. Gifts made within 2 to 5 years before bankruptcy can be held to be void unless the recipient proves the debtor was solvent at that time. Exceptions. What are the gifts that are safe? So gifts made before and in consideration of marriage, gifts to a purchaser who paid fair value in good faith, and gifts of property acquired through the wife's right, which are her separate property. Suppose wife is working and she has acquired any property out of her own income. So, and she gifts that property. So that is safe. That cannot be held to be void. So you cannot give away your property to family or friends to defeat creditors. So DGI can claw it back, holding it void. Section 53. Fraudulent preferences. Paying one creditor over others. What is fraudulent preference? Paying one creditor more than their fair share to the disadvantage of other creditors when you cannot pay all your debts. Because we have seen section 43, which talks of the waterfall mechanism, and if you change the waterfall mechanism, if you do something which changes the waterfall mechanism, then it is treated as fraudulent preference. So any payment, transfer or charge that gives one creditor a preference over others is void if bankruptcy petition is filed within 6 months of the act. Practical example, you owe bank A 100,000 ringgits and friend B 50,000 ringgits. Knowing you are going bankrupt, you secretly repay friend B in full. So this is a fraudulent preference. So DGI can reverse that payment. Exception is A person who received payment in good faith and for valuable consideration is protected and guarantors. So creditor for this purpose includes sureties and guarantors also. Section 53A and 53C, assignment of book debts and fair market value. Section 53A, if you assign, sell or transfer your book debts, money owed to you by customers before bankruptcy, and those debts are not yet paid at the time of an act of bankruptcy, the assignment is void against the DGI. What is exception? Properly registered assignments under another law or transfers made as a part of a genuine business sale are protected. Section 53C. If you sold, bought or received services within 12 months before bankruptcy at an obviously unfair price, court can review such transactions. Too cheap, DGI can claim the shortfall if you sold an asset far below the market value. Too expensive, DGI can claim back the excess if you overpaid for something and the other party stood benefited. So why these rules exist? To prevent smart financial maneuvers to strip assets before bankruptcy is formally declared. Section 60 and 61 talk of the DGI's powers to manage and sell assets. So section 60, it says if you sell any part of the bankrupt's estate through auction or private sale, right? Then give receipts, effectively discharging buyers from liability, prove debts, claim dividends, exercise powers over property, or you deal with the property the bankrupt was entitled to benefit from. So these are the powers of the DGI, which DGI can exercise without the permission of the court. And these powers include selling any part of the bankrupt's estate, giving receipts, proving debts, claiming dividends, exercising powers over property, or dealing with property the bankrupt was entitled to benefit from. There are certain powers which the DGI can exercise with the approval of the court, which are included in section 61. So it can continue running the bankrupt's business, file or defend lawsuits on behalf of the estate, mortgage or pledge estate assets to raise funds, refer disputes to arbitration, settle debts and claims, compromise with creditors on disputed amounts. So the key rule is that the DGI has broad powers but must act in the best interest of creditors collectively. Section 62 to 66, paying creditors, how dividends work. So what is a dividend in bankruptcy? A payment from the estate to creditors proportional to their proven debts. What is the timeline? First dividend is to be declared within 12 months of bankruptcy order unless DGI justifies delay, and subsequent dividends are to be distributed at least every 12 months, and final dividend is to be distributed when all realizable assets have been sold. So rules regarding this are DGI must gazette notice before declaring a dividend. Dividends under 5 ringgits are not paid, too small to be worth the administration cost. So late proving creditors can catch up from undistributed funds before future dividends are declared. Bankrupt surplus, section 69. If all creditors are paid in full, including 8% interest, any remaining money goes back to the bankrupt. Section 59, disclaimer of onerous property. Now what is onerous property? Property that costs more to maintain than it is worth, like a lease with high rent on a business that has closed or shares in a loss-making company. What can the DGI do? It can disclaim or give up onerous property by written notice, releasing the estate from all liabilities attached to it. What are the rules on disclaimer? You cannot disclaim a lease without the leave of the court or everyone's consent. If someone asks the DGI to decide whether to disclaim within 28 days and DGI does nothing, DGI is treated as having adopted or accepted the property. What is the effect on others? Anyone harmed by disclaimer, for example, a landlord losing a tenant, can prove the resulting loss as a debt in the bankruptcy. Why it matters? Without this, the estate would be burdened with liabilities that drain creditor payouts. Now let us go to part 4, which deals with the Director General of Insolvency, sections 70 to 87. Who appoints the DGI? The minister appoints the DGI and a deputy DGI from members of the judicial and legal service. The minister may also appoint directors, deputy directors, assistant directors, and insolvency officers. What is the legal status of DGI officers? All DGI officers are deemed public servants under the Penal Code and they can administer oaths and take affidavits. Section 71 says that DGI has a dual role. It investigates the bankrupt's conduct, looking for fraud and offenses, as also it administers the bankrupt's estate, which includes collecting and distributing assets. So DGI is the government's insolvency administrator. Think of them as both a policeman investigating fraud and a trustee managing assets for creditors. Section 72 and 73, DGI's duties regarding conduct and estate. Section 72, investigate the bankrupt's conduct thoroughly, report to the court if there is reason to believe any offense was committed, participate in public examination of the bankrupt, assist in prosecuting fraudulent bankrupts, and make additional reports as directed by the court. So these are the DGI's duties regarding conduct. Now regarding estate, DGI acts as the receiver of the bankrupt's estate. It acts as a manager. If no special manager is appointed, it can summon and chair creditors' meetings. It issues proxy forms for creditor meeting. It has to advertise the bankruptcy order and key dates, report to creditors on the bankrupt's proposal. It has to consult the creditors on asset management, their directions, override the consultative committee. Section 76, 77A and 78, these include the financial management of the estate. So section 76 says that the bankruptcy estate account, so all monies received by the DGI must be deposited in a government bank account called the bankruptcy estate account. Section 77, surplus investment. If the account has more than it is needed, the minister invests the surplus in trustee securities. Section 77A, insolvency assistance fund. This is a special fund formed for profits or dividends on estate investment. It is used to pay costs when estate funds are insufficient, but only where there is a reasonable basis for proceedings. Section 78. DGI's accounts must be audited by the Auditor General at least twice per year, and bankrupts and creditors may inspect accounts on payment of fees. Why this matter? Because it involves public money handling, transparency, and audit rules ensure that DGI is accountable for every ringgit. Section 82, 85, and 86. DGI's release, directions, and appeals. Section 82 talks of DGI's release. After the final dividend and closure of the estate, the DGI applies to court for a formal release. Court audits the accounts and considers creditor objections before granting a release. It discharges DGI from all liability but can be revoked if obtained by fraud. Section 85, DGI's discretion. DGI uses discretion in managing the estate but must follow directions from general creditor meetings. Creditor meeting directions override consultative committee advice. Section 86 talks of appeals against DGI's order. If you are unhappy with any act or decision of the DGI, you can apply to the High Court. The court can confirm, reverse, or modify any decision of the DGI. So DGI is not about the law. Both the bankrupt and creditors have got right of appeal. Now let us go to part 5, which talks of constitution, procedure, and powers of court. Sections 88 to 105. Section 88 says that High Court has exclusive jurisdiction. So High Court is the only court with jurisdiction in bankruptcy in Malaysia. Section 89 says chambers hearing. The judges may hear matters in chambers which amount to private hearing. Not every case needs a full open court hearing. Section 90, registrar's powers. The registrar, who is a senior court official below a judge, can make interim orders in urgent cases and hear matters referred by the chief judge. Section 91, full powers of court. The court can decide all questions of law, fact, and priority in bankruptcy cases, and court can order non-compliant parties to comply and may immediately commit a defaulter to jail. So if you have a bankruptcy matter, you must go to the High Court. Magistrates Court and Sessions Court have no jurisdiction except the Sessions Court can try criminal offences under this Act. 92. Appeals in bankruptcy. So High Court can review, rescind or vary any of its own bankruptcy orders, and all High Court bankruptcy orders can be appealed to the Court of Appeal. Any person who is aggrieved can appeal, and this includes the bankrupt, creditors, and the DCI. The DCI is automatically treated as aggrieved if any application they made is refused. Practical steps: you file notice of appeal within the time limit. Stay of execution, a pause on the order may be applied for pending appeal, and an appellate court may reverse, confirm, or modify the order. What is the key takeaway from this? No bankruptcy order is completely final. There is always an avenue to challenge it. 93 to 99. How the court manages the bankruptcy cases. So 93 says that the court has discretion over costs and it can extend time limits and amend documents. 94 talks of consolidation. Multiple petitions against the same debtor can be consolidated into one case. 95 talks of carriage change. If petitioning creditor is slow, court can substitute another creditor or give control to DGI. Section 96, death of debtor. If debtor dies during proceedings, the case continues as if they were alive. 97, stay. Court can stay proceedings at any time for good reason. Section 98, partners. Creditors can petition against one partner of firm without suing all the partners. And Section 99 talks of multi-respondents. Court can dismiss petition as to some respondents but continue against others. Section 100 to 103, bankruptcy of partners and firms. Section 100, consolidating partner bankruptcies. If one partner is bankrupt and then another partner is also petitioned, the cases are consolidated. Section 101, DGI acting with partners. DGI can bring joint legal actions with the bankrupt, non-bankrupt partners to recover debts owed to the firm. So non-bankrupt partners cannot release firm debts when DGI is acting. Section 102, joint contracts. A non-bankrupt co-contractor can sue or be sued without joining the bankrupt. Section 103, proceedings in firm name. Partnerships can be proceeded against in their firm name. And why these rules matter? Because bankruptcy of one partner does not automatically destroy a business partnership. The law tries to preserve what can be saved. Section 104 and 105 talk of international cooperation and annulling bankruptcy. So Section 104 says that Malaysian courts will assist Singapore and other designated countries' bankruptcy courts and vice versa. A Singapore bankruptcy order is recognized in Malaysia. The bankrupt's Malaysian assets vest in the Singapore official assignee. This prevents a bankrupt from hiding assets by moving them across the causeway. Section 105, annulling a bankruptcy order. So court can annul or cancel a bankruptcy order if the debtor should not have been made bankrupt in the first place, or all debts have been paid in full, or proceedings are better handled in another country, say Singapore. What is the effect of annulment? Property reverts to the debtor and all prior DGI acts remain valid, and a court notice of annulment must be gazetted and published in a local newspaper. Part 6, small bankruptcies. Section 106 to 108. When does summary administration apply? When the DGI reports to court that assets after secured creditors are paid are unlikely to exceed the prescribed value. What is simplified in summary administration? No appeals from court orders except by leave of court. So it ensures fewer challenges. Estate is distributed in a single dividend wherever practical. So faster distribution. And other procedural simplifications may be made by ministerial rules. So what stays the same? The bankrupt can still be examined publicly if the court orders it, and the bankrupt still has the right to be discharged. Why this exists? Full bankruptcy administration is expensive Where there is very little money in the estate, simplified rules save time and costs for everyone. Section 107 and 108, special rules for wage earners. Who is a wage earner? A salaried or wage employee whose income is within the prescribed limits and he has no business trade income. So what happens when a court finds a judgment debtor is a wage earner? Instead of jailing the debtor or making a payment order, the court refers them to the DGI for bankruptcy proceedings. Section 108. No public examination for wage earner bankruptcies. If the DGI confirms the bankrupt is a wage earner with no trade debts, the court may administer the estate summarily and there is no public examination, so less humiliation is there. And interest normally payable on surplus under section 43(5) is also waived. Why this matters? Wage earners who become bankrupt through unfortunate circumstances and not due to business fraud are treated more gently by the system. Part 7. Fraudulent debtors and creditors, sections 109 to 119. Part 7 makes it a criminal offense for a bankrupt to lie, hide assets, falsify records, or defraud creditors. The general penalty is up to 2 years imprisonment and or fine. So these offenses can be prosecuted even after the bankrupt is discharged. So bankrupt must to prove their innocence. For most offenses, the burden partially shifts to them. For example, unless they prove no intent to defraud. Sessions court have full jurisdiction to try these offenses, making prosecution easier and faster. Even a creditor who makes a false claim in bankruptcy is guilty of a criminal offense. Section 109. Crimes a bankrupt can commit. What are the key offenses? Major offenses which could lead them up to 2 years in jail, hiding property or debts from the DGI, failing to hand over property or documents to DGI, concealing or destroying books and records, fraudulently removing property, valuing 100 ringgits or more, making false entries or omissions in records, obtaining credit of 1000 ringgits or more without disclosing undischarged bank status, running a business or entering contracts without disclosing bankrupt status, using false representations to get creditor approval for a composition, and gambling or rash speculation that materially worsen the insolvency. So such major offenses can lead the bankrupt up to 2 years in jail. What is the defense available? For most offenses, the bankrupt can avoid conviction by proving they had no intent to defraud. Section 110 to 116, more fraudulent offenses. 110 says, if no proper accounts are maintained, so traders who were bankrupt and did not keep proper books of account for 2 years before petition face up to 2 years of jail unless unsecured liabilities were under 4,000 ringgits for a first bankruptcy. Section 111 says, debts without ability to pay. Incurring debts within 12 months before petition while knowing you cannot pay. So it is considered to be a criminal offense. Section 112, absconding with property, leaving Malaysia with 50 ringgits plus of property that should go to creditors. It could lead you up to 2 years in jail. Section 113, absconding to avoid process, leaving Malaysia to avoid service of bankruptcy notice, up to 1 year in jail. Section 114, obtaining credit by fraud, getting credit under false pretense after bankruptcy, up to 1 year in jail. Section 115, false claim by creditors. So creditors who make false claims in a bankruptcy can be jailed up to 1 year. And section 116, fraud in composition, debts incurred by fraud remain enforceable even after a composition is agreed. Part 8, supplemental provisions, sections 120 to 139. Section 120, married woman. A married woman is subject to this act in all respects as if she were a single person, female soul. Historically, married women had limited legal capacity, so this section ensures equal treatment. Section 121, corporations and companies are excluded. A bankruptcy order cannot be made against any corporation, company, or registered association. Companies face winding up under Companies Act 2016, and partnerships are not companies. They can be declared bankrupt under this act. Remember, sole traders and partnerships under this Act, private or public companies under Companies Act, and this distinction is critical. So wrong law is dismissed petition. Can you pursue a dead person's debts? Yes. A creditor can petition for administration of a deceased debtor's estate in bankruptcy. Who can petition? Any qualifying creditor when debt is sufficient to support a bankruptcy petition. The DGI may also petition directly. So section 122 says that when a debtor dies while insolvent, the remedy can still be pursued by the creditors or DGI. What are the key conditions? You must wait 2 months from probate or letter of administration unless agreed or debtor committed an act of bankruptcy within 3 months before death. You cannot petition if formal estate administration has already started unless court allows it. What is the effect of the administration order? DGI takes over all the estate property, same as in case of a regular bankruptcy. Funeral and testamentary expenses are a priority debt, and surplus after paying all debts goes to the legal representative, executor, or administrator of the estate. Section 123 to 129 regarding rules, fees, and evidence. Section 123 says the minister can make rules to carry out the objectives of this act. Section 124 says the minister sets fees for proceedings and all fees go to the consolidated fund of the government. Section 125 says that a gazette containing a bankruptcy notice is conclusive proof of the order being made and courts must accept it without further evidence. Section 126 talks of minutes of creditors' meetings. These should be signed by the chairman are admissible as evidence without further proof. Section 127 talks of court documents. So sealed court orders, affidavits, and certified copies are admissible evidence in all legal proceedings. 128 talks of affidavits. Affidavits sworn in Malaysia, Singapore, UK, or before a council abroad are valid for use in Malaysian bankruptcy courts. Section 129 says regarding deceased witnesses, so depositions or sworn statements of a deceased witness can be used as evidence. 130 to 135, service, defects, stamps, and books. 130, notices. Notices may be sent by prepaid registered post to the last known address or by electronic communication with consent. Electronic service is deemed served when transmitted. Section 131. Minor procedural errors do not invalidate bankruptcy proceedings unless they cause substantial injustice that the court cannot remedy. 132 says that all deeds, conveyance, orders, and documents in a bankruptcy are exempt from stamp duty, so this reduces costs. Section 133 says that corporations act through authorized officers, firms act through any partner, mentally disordered persons act through their committee or curator. 134 says the unclaimed dividends remain in the bankruptcy estate account for 7 years, and after 7 years, they are credited to the consolidated fund. You can still claim from the government if proven. Section 135. No one can withhold the bankrupt's books from the DGI. No lien is recognized. Creditors may inspect books at the DGI's office. Section 137. I think we can take a break here for 5 minutes and then we will resume again. So it's 5 minutes bio break.